The Speaker doesn't decide the disqualification. The facts are clear. They are covered by a judgment of the court. They are covered by several judgments of the court. You don't decide it. The Election Commission disregards the organizational wing, decides on legislative majority, which should not have ever happened, that government should never have been formed because they were deemed to be disqualified. People in power are like a magnet, as your Lordship knows. That magnet attracts a lot of disparate people, even disgruntled people or happy people, because they look for new prospects. So your 31 will become 39 and 39 will become 56. Give this power to the Commission that at a given point in time they can say your constitution is unconstitutional, we will not deal with it, we will not look at it. See the consequences of that and the politics of this.
Bigger question will become when the entire party has to be derecognized.
Correct, to do it. Well, send me a notice that I will de-recognize you. You send me a notice. Please send me a notice. That's not
the notice, Mr. SIBAL. See the second ground. Second ground is 89. When Bala Saheb Thackeray, leader, was there, a notice was given.
Yes. Thus, the organizational wing of the political party is the basis on which a candidate is able to contest the election as a member of the political party. And even after election, his name is recorded along with the political party to which he belongs. To disregard the organizational wing is being based on an undemocratic constitution and instead rely upon the legislative wing, which owes its origin to the very organizational wing, is completely absurd and unlawful. Despite finding that both parties had relied on the 2018 constitution, and despite the same being duly supplied to the Commission, the Commission held that the same was not categorically taken on record. Malas, where is it in the section 29A? Where is it that an amended constitution has to be taken on record? We must inform the Commission of the amendments. The only constitution that is taken on record is at the time of registration, because the guidelines to the Commission say that you will have to, in that constitution, have a provision for amendment of the constitution. So, as and when we amend provisions, we inform the Commission of what is amended. That's all. Though it is our case that we gave it along with the letter, but we can't now prove any of that. They deny it. But the fact of the matter is, where is that requirement? Moreover, the Election Commission erroneously held that the 2018 constitution was not democratic. Based on these untenable reasons, the Commission has based its entire decision-making process on the legislative majority employed by the respondent. See the but see, the unjustness of this kind of a analysis. The Speaker doesn't decide the disqualification. The facts are clear. They are covered by a judgment of the court. They are covered by several judgments of the court. You don't decide it. The Election Commission disregards the organizational wing, decides on legislative majority, which should not have ever happened, that government should never have been formed because they were deemed to be disqualified. And then, the whole process takes place, and then they get everything, the party, the symbol, and these people in power are like a magnet, as your Lordship knows. That magnet attracts a lot of disparate people, even disgruntled people or happy people, because they look for new prospects. So your 31 will become 39 and 39 will become 56. And if you let that happen, which is, I think it was, according to me, and we will in another case argue, this is a wrong procedure to adopt. To let the disqualification linger, hopefully in another case I'll argue that. So, now 22 to 2023. At the time when the split took place, they had 20 members, 1 member of the Lok Sabha. We had 21 members of the Lok Sabha who were with us. 18 Lok Sabha and 3 Rajya Sabha who were with us. They all went away after he became Chief Minister. It is bound to happen. So it's this creeping majority that takes over because power attracts. Anyway, the petitioner filed SLP number so-and-so against the final order dated 17/2/23 and 20/2/23. Notice was issued in the SLP, and interim directions were passed by the commission, by the court, continuing the name Shiv Sena, Uddhav, Balasaheb Thackeray, and the symbol. Flaming torch allotted to the petitioner group by the interim order dated so-and-so, passed by the commission. The Constitution Bench of then, we come to Subhash Desai's judgment. Kindly see, political party and the kindly look at Subhash Desai's judgment. You will find that at the compilation. Okay. I just give it to Malas.
I can show it to you.
Yeah.
He doesn't have the new one. I'll give you the page numbers of the new one.
That I'll tell.
ठीक है.
What the original judgments volume was too thick, 400 odd. We don't need that. So we've sort of made a smaller volume for your lot.
Also stop when.
It's easier this way, Malas.
All the relevant ones are there.
Yes, all the relevant judgments. So if you look at Subhash Desai straight away, which para? Para 109, page 71. Whereas if your lordship looks at para 104, page 69 for a minute. They're just the heading, just above para 104, the heading is political party and legislature party are distinguishable concepts. Lordship has that? Then you come to para 109. That's at page.
Paragraph is SIBAL.
But first paragraph 104, just above that, at page 69, just the heading of paragraph, above paragraph.
The power
Political party and legislative party are distinguishable concepts. That's where the learned judges discuss, this issue. And come to 109 then. Bottom of page 71, last paragraph. Political party and legislature party cannot be conflated. The contention of the respondents that political party and legislative party is inextricably intertwined is erroneous for the following reasons. So they reject that argument. Parliament in its constituent capacity was conscious of the necessity of not allowing anti-defection laws to stifle intra-party dissent and the freedom of expression of legislatures. It was with this objective that the defenses of merger and split, which was later omitted, were introduced. The 10th schedule confers legitimacy to the actions of the legislatures, which would otherwise lead to disqualification if a substantial number of legislators, 2/3 in the case of a merger and 1/3 in the case of the erstwhile provision for a split, disagree with the political party. The 10th schedule recognized the independent exercise of the legislature party to the limited extent of presenting a defense to the actions of the legislators, which would otherwise have amounted to defection. Kindly see,
They are only relevant for the purpose of the defense.
because the whole purpose of both paragraph 3, which is now erstwhile, and 4, is as a defense. So if I seek disqualification, the defense can be in a situation of a split under paragraph 3 that I am 1/3. In paragraph 4, that I am merged. The political party has merged and 2/3 of the legislative party has agreed to the merger. As a defense. But you can't interpret it. I'm sorry.
Yeah.
Section 29A of the Representation of People's Act requires an association of individuals calling itself a political party to be registered with the ECI. The party need not have returned candidates to the assembly to be registered as a political party. Under the symbols order, a political party receives recognition as a state party or a national party based on the total number of candidates returned to the assembly by the political party and or the total percentage of votes secured in the election. The purpose of the requirement on the symbols order is to identify whether the political party has a substantial presence in the electoral fray to freeze an electoral symbol for that party. The symbols order does not refer to an association of legislators. Dehoards the political parties. Like the 10th schedule, it recognizes a legislator and a political party. Thus, the reference to provisions of the symbols order to argue that the concepts of political party and legislative party are intertwined does not hold merit because the concept of legislative party is not recognized by the symbols order. This is very important. It's only the political party which is recognized.
The primary substrate of political.
That's right.
From that springs the legislative.
Absolutely. And if you base your decision on the legislative party, then it's a problem.
Well, up to 161 and 162.
161.
I was indicating.
Yeah,
The two decisions operate on different planes.
yes, that's correct. They do, Malaz. But the facts, but they must be there for them to operate. I'm reading it with, I have marked it, Malaz. I myself marked it. I marked it in yellow here, Malaz, because I knew I will read it. I'll read that, Malaz. At this stage, a question may arise as to whether the decision of the ECI under the symbols order must be consistent with the decision of the speaker under the 10th schedule. The answer is no, and I agree. I agree, Malaz. The question is, what are the basis of that decision? Of course, they can be different.
That is the reasoning which made with the bench to allow the proceedings to proceed simultaneously.
But try it. But Malaz, see what? Of course, it can proceed. But nobody knew that they would not decide the disqualification. we must, Malaz, know the reality. Nobody knew.
Dragging of the feet.
Yes. Reply in 23. And then deciding it on the basis of legislative majority. So what it makes Malaz. That's why ultimately, Malaz, institutional integrity is the heart of democratic way of functioning. Absence of institutional integrity destroys the very foundations of democracy. This is the problem. Commission.
Eloquently quotes of institutional integrity.
It does, yes.
Quoting Dr. Ambedkar.
Then Kyoto Hollehorn repeats it. And they say this is a constitutional sin. That's what Kyoto says. Defection is a constitutional sin, Malaz. Now it's a badge of honor, not a sin anymore. The decision.
Paragraph 92 of the symbols order.
Yes, absolutely. Of the symbols order.
Dr. Ambedkar saying that howsoever good a constitution may be, it is sure to turn out bad.
That's
because those who are called to work it happen to be a bad one.
In fact, we are relying upon it, sir. In fact,
And
we
how
are
was that?
What's the point of relying when the authorities don't? You may rely, but the authorities don't.
That's what is our case.
That's our case, Malaz.
That's why I said paragraph 92 actually voices your concern.
Sorry?
163 is what you are trying.
Yes, I will just, yes. Then, Malaz, the decision of ECI has prospective effect. Now, first of all, Malaz, let's finish that. The answer is no. This is because the decision of the speaker and the decision of ECI are each based on different considerations. Correct. I have no dispute with that.
Ultimately, you also need to respond that originally your party constitution was completely based upon democratic principle. And then you suddenly brought an amendment and creating complete convention.
We didn't, Malaz. I'll show that to your lordship. I'll demonstrate that. But Malaz, the question is, this is not the remit of the commission.
In it, when we talk of democratic principles in different institutions governing the democratic values and the ideas, then question would arise that, well, as a political party, are you also not supposed to adhere to those principles?
I appreciate, Malak. The question is, there are institutions that perform a constitutional function. There are institutions that perform a political function. I think the level of, what should I say, integrity is much higher when you are performing a constitutional function. Whereas a political function can be rectified, but a decision made by a commission, seldom, in circumstances, can never be rectified. And this is what happens, for example, somebody could have said, you please change your constitution. We know of several cases where organizational elections are not held for years. Major political parties. Has anybody said it's done democratic and therefore I will take action and I will not recognize your constitution?
That is the line of reasonings on which the 2018 amended constitution is not relied by the election commission.
But that they can't do, Malas. How can they get into this in a paragraph 15 order?
Demonstrate that before us.
I'm sorry, Malas?
You demonstrate that proposition.
Yes, Malas. It says for
Kind of the
no, Malas. I'm sorry, Malas. First of all, why do you say the 2018 constitution is undemocratic?
See paragraph 95 of the symbols order, impugned order.
Yeah, sure. 95.
That's the conclusion on the party constitution.
Page 503.
Page 503, Malas.
Yes.
Of the convenience.
That's why they say we'll go to the test of majority.
But Malas, the question, he's got if both parties have.
Mr. Sipal, we want you
PDF 5
to see 95 because we want you to respond as to the.
I will respond immediately. The above facts give traction. The above facts give traction to our previously noted concerns of the surreptitious nature in terms of non-communication of amendment and equally importantly, the process of amendment in the constitution of the party not being in accordance with the conditions as communicated by the Election Commission of India dated 1910-89 to Shiv Sena inter alia, stipulating in para 2 the statutory requirement under 29A. Further, this is not in sync with clause such and such of the guidelines prescribed in exercise of the powers conferred by 324 and section 29A. In view of the aforesaid, the test of party will not come in at the aid of this commission in deciding the present case.
Now you deconstruct this paragraph.
Yeah,
Deconstruct this paragraph. There are three grounds on which
correct.
the party constitution is not relied upon.
Yes,
A, non-communication.
yes,
B, not being in accordance with the communication made by the
Right.
ECI,
right,
dates letter dated 1910-89, and being in breach of paragraph 2 of the guidelines
right,
prescribed by ECI.
right.
And show us whether it's factually incorrect
Yes.
or it's legally untenable.
Both. I will show both. Both factually incorrect and legally untenable.
This is the summum bonum of your argument.
Yes, I will show it both factually and legally untenable. I'll show that. But let's give this power to the commission. We've had enough powers with the commission. Let's give them another power and see the consequences of it.
We want to test.
Well, let's test it. But let's give this power to the commission that at a given point in time, they can say your constitution is unconstitutional. We will not deal with it. We will not look at it. See the consequences of that and the politics of this.
Bigger question will become then the entire party has to be derecognized.
Correct, to do it. Well, send me a notice that I will de-recognize you. You send me a notice. Please send me a notice. That's not.
The notice, Mr. Sibal. See the second ground. Second ground is 89. When Bala Saheb Thackeray, leader, was there, a notice was given.
Yes.
Now, what
He
you
corrected
say
it.
is, after that, you
He
have
corrected it.
created an amended constitution,
Correct.
but both of you claim there is an amended constitution.
No, not only that, he got benefit. He became a legislator because of that constitution.
Your affidavit
Well, let's kindly see. You take the benefit of it and then you say, now you'll not look at it. This is the argument. You became a legislator, you became a minister, you got a ticket from the party, you became a member of the Karani, and then you say, look, don't look at it.
From that angle, it will not be the question of that your interest he conduct. The question will be the legality of the order of the commission.
No, Malaj, I'm sorry. This court has said, if there are two people who claim under the constitution, you can't go behind it. There's a judgment of this court.
Lord, also, my lord, just apropos what has fallen from your lordships, election commission, my lord, there are 5 judgments of the election commission.
Cannot go to the constitution.
Yes.
And number 2, my lords, where the other party
Has got the
also relies upon so-called undemocratic constitution.
You can't go behind.
Then, my lords, election commission has said we can't get into the dispute, and we will go by what is there on the record.
Mr. Sibal, Mr. Kamal, we pointed out this paragraph
Yes,
for
madam.
you to respond.
Malaj, this paragraph is an act of genius to ensure that you don't look at the organizational structure. That's my answer to it as far as the reality is concerned. It's an area of
more forensic approach.
Malaj, I'm sorry to say, we sit here not realizing the realities of what happens on the ground. And Malaj, if we allow these realities to continue and give this part of the commission, the consequences will be very grave. That's all I can say. But I'll answer that question in any case.
दोस्तों, कपिल सिब्बल की इन तीखी दलीलों और माननीय सुप्रीम कोर्ट की इस गर्मागर्म बहस ने महाराष्ट्र की राजनीति में फिर से हलचल मचा दी है। सवाल बड़ा है, क्या विधायकों की संख्या ही असली पार्टी तय करेगी या फिर उद्धव ठाकरे का संगठन अपनी पहचान वापस पा सकेगा? माननीय कोर्ट की इस रुख पर आपकी राय क्या है? क्या सिब्बल के तर्क सही हैं? कमेंट्स बॉक्स में अपनी राय जरूर लिखें। जय हिंद दोस्तों।